getting ready. YouTube. Someone, Judge Hale said when she was this morning on YouTube, someone posted a message. This is cool. Someone outside was watching.
Okay, we good.
Okay.
So right now, he's only had one monitor. You need to get another one.
I don't need another. In this case, I just need the one.
Okay, we'll definitely get you another monitor for there.
Yeah,
It's easier to have the Zoom on one and be able to run Aztec or Ajax.
This is one case. This is actually not a county case, so we don't. It's not. It's sort of an.
Okay.
Gotcha.
So this is your Zoom.
Okay.
And this on the browser is YouTube, so you don't have to worry about this. I can close this one down for you. You don't have to worry about this one.
And then when someone pops up, say admit to the meeting. And
and then you go in here, participant right here, and whenever you sign in, you will see his name right here.
And sometimes you've got to click unmute.
Yeah.
And then if that has red, you have to right click it and say, I can't remember, ask
to join.
Or ask to start video or something to that effect.
We'll see. All right. We'll see. I've got
we will stay here until the defendant comes.
Yeah. I'm going to have an attorney from Nogales, attorney from Tucson, and perhaps a defendant from Sonoyta, unless he just calls in. And I don't know how he's going to participate.
Well, there's actually, when you send out the meeting, there are numbers that they can call and still be included in.
Yeah, he has an attorney for now, but he wants to get rid of the attorney. So I sent the notice just with the attorney. So I hope the attorney forwarded it to the defendant.
Oh.
I'm assuming that she did.
Yeah.
Okay. So it's a little while. You guys come back in about 10 minutes or so. It's not till 2 o'clock. And then
you want to grab another monitor real quick?
I don't need it. I mean,
yeah, let's do that before. I'll do that after he's.
Okay.
All set.
All right, let's go. Come back. I'll come back in
We'll come back
10 minutes or so.
I can reduce this and circle the internet for a while, huh?
Yeah.
Does that work?
Yeah, I got me. Come see. Hey, look. Come see how you looking.
Look, I'm on the news. Okay.
And there's a Zoom. Here's the YouTube channel. Where's the YouTube channel? think this is the YouTube channel. There's this is you stream on YouTube. The YouTube stream's a little delayed.
Oh.
See, it's delayed. See, I'm talking to you just now.
And remember to sign off YouTube and all the other stuff before you talk.
So this is the live version. Now the people involved,
Okay.
so you know.
Let me, I may know them.
Okay, defense attorney is Victoria Truel. Defendant's name is Peter Pototsky is the defendant. Now he may, I hope he appears or listens in.
This is the docket number? No.
It's out of Nogales, yeah. It's okay. It's in Nogales. It's in the Nogales City Court case. And the attorney on the second page, you showed Greg Solaris, I think is the name of the attorney for the city.
Oh, it's not? No, wait.
Greg Solaris.
Oh, city attorney. Oh, from Nogales.
Yeah.
Oh, so they're none of our attorneys.
None of them. These are all.
Oh.
And the defendant lives in Sonoyta. This is the basis of an event that happened at a board of supervisors meeting in Santa Cruz County.
Oh.
And the defendant, I guess, the case has been, it started out, I think, in Nogales Justice Court. It went to Nogales City Court. And it actually came up here to Pima County Justice Court. Went to 2 judges there. It went back down to Nogales, and now it's got me.
Wow.
No one's happy with anybody. So they had
They had to go outside.
outside.
Well, that's funny.
We're probably live, so be careful what you say.
Oh, I ain't saying nothing. You are saying. Wow. I would say I had family in Nogales, Arizona, but not very, I think just a cousin now. Everybody left and everybody's passed away, so.
I don't know anybody in this
Then-
case.
Patagonia, I still have family there. And then, who else? Sonoyta? No, I just used to go to earlier there. Interesting.
Todd and Kid are going to come back. I told him.
Oh,
Wait till
when you go on.
yeah.
So what did, oh, okay, this man probably got belligerent at one of the,
It's something happened to the board of supervisors, as I understand it. There was a board of supervisors meeting dealing with in Santa Cruz County, took one of JP,
or somebody.
yeah. This is Miss Romo, who's the clerk of the city, is listening in. Romo.
Roma,
Nogales, see that the clerk.
oh, she's probably gonna,
Rosa Romo. Nogales City Senior Court Clerk.
Rosa.
Hello, can you hear me?
She might be.
Hello, can you hear me?
They might be muted over
Muted
there
over
on their side. You're not muted, right?
No, I don't think
Okay,
that.
so that's probably them. That's what I heard the other judges tell the other people.
You may be muted on your side. I can't hear, if you're saying that, I can't hear you.
No, what we need to know is if we're gonna be in court with you guys, what's the calendar? So we can prep the file.
Each judge, until June 1st, each judge will have their own calendar, so you have to talk to the judge. Once we get to June 1st, then it'll be regular, like what's ever in Aztec, Ajax.
Okay, because that's what happened the other day with Hale, that Patricia was in there. Nobody told Patricia till she walked in at 8 o'clock in the morning.
I know Judge Maldonado has hearings Tuesday morning, and I don't know who's scheduled to do it with her. You may find out because she's, and then I think,
Tuesday morning,
yes,
I wonder if she's in the office.
I've got a list of who's got hearings scheduled. I know she has Tuesday. I know there's another set of hearings next. Hale may have another set. Close may have another set next week.
No, Hale said she's not here next week.
That's right, she's gone. So Close may have his hearing set next
The
week.
close only says like 5 or so, not a huge amount. That's the only thing that holds us back is doing it as we're not prepared.
Well, once we get to June 1st, it'll be a different story because then it'll be everyone, it'll be a normal count, whatever's in Ajax.
Ajax, okay.
You'll be able to use Ajax and they should print out a calendar.
See, the calendars are different too. We didn't know the calendar, but I told Hale to forward me the copy of it. And she did, that's how I knew. And I scheduled them on Tuesday. I did the paperwork for her. I'm like, okay. That's why I went kind of smoothly today. Because everything was in. In the morning, you said?
I believe, yeah, Maldonado has stuff in the morning. She asked to have that morning. Now, whether she said anything, I don't know.
Because she has 34 set. But actually, it's her transport.
So you have to talk to her to see what she's actually got.
And Mr. Ricardo Bors, no. Puerta's not taking cases.
Yeah, I saw that email.
Like he said, he's bombarded. We haven't been open.
If he's getting anything out of DV is still going nuts. And I don't know if he's gotten anything out of DV. My guess, because I think he sent the note to Million, so my guess he's got cases out of Million's court.
There's a lot of attorneys. Oh, she starts at 8:30. Like once she's already done.
Ms. Romo, can you hear me?
I can hear you, Judge.
Okay, so you can hear us gossiping over here?
Yes. I don't have a video in the computer, but I can hear you. I can see you also.
Okay. And this is actually being streamed over YouTube Live.
Okay.
That way, if anyone argues it's a public hearing in that sense, we're creating a record here. I'm going to keep it as a Nogales case, just conducting, I guess I'll be like a pro temp for lack of a better term. But we'll have, the record will be here. So if that becomes an issue, we can shoot you off a copy of the record where we use FTR. I've got one person on just audio only.
Okay.
And we got computer IT people. We're still learning. We're still perfecting this method over here. So I have to have them.
Okay.
I have to have
IT,
backups.
that's okay.
Are you guys using this stuff yet?
Excuse me, Judge?
Are you guys using video hearings yet?
No, this is the first time also as well.
We've got several judges here. She doesn't have a video camera. So
Oh, okay.
She can see me
I can see that.
and she can hear. We've got several judges who are using them all the time, and they love those who use them, love it, because you can connect and you can see each other, and you don't have to come to court. So especially cases involving attorneys is really useful. And if defendants have as long as they have an email address and an internet connection, they can participate also this way.
That's great.
And the softwares, you're in ACAP court, right?
Yeah, we're in AJAC.
Yeah, Ajax ACAP, but are you part of the Supreme Court ACAP system? Well, they monitor.
Yes. Yes.
They have the Zoom software free we got ours from the AOC for free.
Oh, cool.
As long as you've got a computer that's video and audio capable, you can download it and use it. And they have instructions when you go to SharePoint, to Wendell, and then Wendell, they have some tutorials. But if you call AOC, they'll help you set it up. Because this, allows hearings to be done remotely. So, like I said, I've got 4 judges using it regularly right now.
Cool.
2 that aren't at all, and 2 more that want to learn how to use it. They've been doing hearings for the last 2 weeks. Even though we're closed, they're doing hearings still.
Okay.
Waiting to see who else joins us so far. Well, it's still a few minutes early.
Yes, we are. So I probably just have to open a remedy ticket, Judge, to have a download to our system.
Yeah, is that true?
Yeah, that'd be a good start.
That's our IT person speaking, one of our IT. He said it'd be good. You heard him?
No.
He said it'd be a good place to start. Because what they did is they sent us an email with the app. You can download the app, and then you have to learn how to use it.
Oh, cool.
They do accounts too. So.
And you have to be assigned accounts. And because when they send you something, they assign you an account, and you log in using your ACAP login, whatever it is, at courts.ac.gov. And you can download it on computers. I have it on my office, and then I have it here in my courtroom.
Oh, that is so convenient right now, especially right now.
Right, and almost every attorney has an internet connection, so you can do the case like I'm sitting here in Tucson, and Mr. Solaris, I assume, is down in Nogales, Mr. Troll is up here, and I don't know about Mr. Pototsky, whether or not, he should have, I assume Mr. Troll sent him a copy of the notice. I sent him a copy of the notice, but whether or not he got the law.
Oh, okay.
I don't know. We'll find out soon enough. I know he has an email address because he emailed you a bunch of documents.
Oh, yes, my God. Sometimes it's like his files is so big. Because we do file everything he sent, even though we tell him, you need to contact your attorney.
Next week's files. Right. Oh, someone's trying to come in. P2.
So their mic, so click on that and unmute. There you go. Yeah, it's doesn't respond right away, so just click it once and you're good.
Mr. Pototsky? Mr. Pototsky, can you hear me? Can you hear me, Mr. Pototsky? Shows you're unmuted.
He has to unmute.
Mr. Pototsky, you may be muted at your end.
Testing, 1, 2, 3.
Okay, there you are. We got you. Right
Okay.
now, you and Ms. Romo are the ones on. We're waiting for the Mr. Solaris and Ms. Troll to join us. Okay? As soon as they,
All right.
we'll get going.
Do you feel comfortable?
I got 2 more people joining, so I should be okay.
Okay. If you need us, Liz.
Some are on video, some are not, correct?
Yes, Ms. Romo does not have video, but she can hear.
Okay.
Mr. Pototsky, I'm being told, okay, now you're back on video. Okay, now you're back. For a while, we lost you, but I think I got you back.
This is the first time that you're doing this?
I've participated, but I've not hosted. Yes.
I'm gonna do her Zoom
Oh, you got it filed for Monday, for Tuesday?
for Tuesday, because Buddy does.
Give a couple of minutes and give them a call. All right. So that's what Judge called it out. I also think I could call people. Like, all right.
Or send them another invite for them if they're on the computer. That's what Judge Hale did.
And Ms. Troll is joining us here. Just a second, let her kick in.
Okay.
Okay, Ms. Troll, you okay? We have, still waiting for Mr. Solaris, but we have Mr. Pototsky's on here, Ms. Romo's listening, and I'm here, so we'll give Mr. Solaris a minute or two here to join us, and then we'll go, then we'll proceed.
Yeah, Mr. Solaris had an issue with the link, so I just resent him
Okay.
the information. So he should be on here momentarily.
Where do we put these?
Come over
So you know we're used to having so much.
here. Oh, here we go. Okay, Mrs. Solaris, we're getting them connected up here. Okay, Ms. Solaris, you can hear us? You might be, Ms. Solaris, can you?
Hello, Judge.
Hello, Ms. Solaris, welcome. Got everyone on board here. Let me state for the record before we get started, this is actually being streamed right now live as we know it on YouTube. So it's that way, in essence, it is a public hearing, just so that you know. Now, whether anyone's actually watching is a different story. Okay, for the record, we're here in the matter State of Arizona versus Richard Pototsky. It's Nogales case number CM19-039. I'm going to keep this case as a Nogales case since it's their files and all, but proceedings will be handled. I will preside over all proceedings. The record will be here, and because it's necessary for an appeal, we have FTR, so we can produce an audio record of this, any proceedings that we do. For the record, I will show Mrs. Solaris for the state, Ms. Troll for the defendant, and the defendant, Mr. Pototsky, is also present via video, and Ms. Romo is also listening in, who's the clerk of the court in Nogales City Court. All right, I guess the first issue we have to do, we have a number of motions pending, but probably the first one we have to deal with is Ms. Troll's motion to withdraw. Ms. Troll, do you have anything to add?
No, Your Honor, nothing else apart from what was in my motion.
Okay. Mrs. Solaris, any response?
No, Judge.
Okay, Mr. Pototsky, do you have anything to say?
No, Judge.
Okay, I guess I will go ahead and allow Ms. Troll to withdraw. Then we'll proceed. Pototsky, you're on your own at this point in time. So Ms. Troll, you're free to go unless you just at least want to finish hearing this out at least today. Then I show we have a motion to dismiss filed, I believe, by Mr. Pototsky before Ms. Troll came in, and then Ms. Troll herself filed another motion to dismiss. Am I correct in that?
Yes.
Okay. Mr. Pototsky, I guess it's your motion. So what, do you have anything to add other than what's in the pleadings?
No.
Okay, Mr. Solaris, your response?
Objection.
I'm sorry.
It's an objection, if I understand it correctly.
Yes.
This is basically a Rule 8 motion, as I understand it, for violating time limits. Is that correct, Mr. Pototsky?
That is correct.
Do you understand the concept of included and excluded time?
I'm not talking about excluded time at this time. I'm talking about Mr. Solaris's response to the motion. I don't see how he can respond to the motion. He had the opportunity under Rule 8 to respond. He failed to do so. He was ordered to respond by a certain date by Judge Waters. He failed to do so. He failed to respond to Ms. Troll's motion. So I don't see how he can respond at this point if he's just flagrantly ignored the rules.
Mr. Solaris, response to this?
Judge, first of all, the state did not, we never filed any motions to continue, so we'd never asked for an extension in this matter. The state did file a response to the motion to dismiss and the Rule 8. Since then, it's been filed many months ago, and the defense has had sufficient time to respond to that as well. So we don't feel that he's been prejudiced in any way.
Note for the record, there is a response to motion dismissed filed or dated October 18th. Have you seen that, Mr. Pototsky?
Yes, Judge. 2 months late, August, September, October.
At that time, it was bouncing between judges, am I correct?
I'm sorry.
Out because there's no prejudice involved. So once again, we're back to the issue of Rule 8 issues. Do you have anything further to add?
No, Judge.
Mr. Pototsky?
No, Judge.
Okay. I'll note for the record, the Supreme Court orders dealing with this current health situation, all time is stayed as of early March, so we're only dealing with the period from the date of arraignment, which, as I'm showing, was originally scheduled for April 16th of last year, continued April 30th, and then a number of motions filed by the defendants, and which resulted in this case going to, what am I, about the 4th or 5th judge on this matter. And I haven't done a Rule 8 calculation, but just eyeballing it, I think we've not run into it. There's not a Rule 8 issue. I'll go through and I'll calculate it and send out my calculations, but this is mostly excluded time because the motions filed by the defendant throughout the course of this case. And Mr. Pototsky, other than the Rule 8 issue as a grounds for a motion to dismiss, what other grounds are you alleging as a motion for a basis for motion to dismiss?
I believe all of them were listed in my 30-plus page motion.
The one dated August 26th?
Yes.
I've read it, and most of them are factual issues that don't have to be determined at a trial. They're not issues that can be dealt with on a trial basis. So, I mean, a lot of them are dealing with the facts of the case, and they are defenses to be raised at trial. The motion that I'm looking at is staple came off, so it's 27 pages. And now those motions, based on what I'm seeing, other than the Rule 8 motions, all these others are just deal with the facts of the case. I'm denying without prejudice. They can be raised at trial if we get to that, when we get to that point. Are there? And then I show you also filed a motion dated August 5th, I believe, and a motion to preclude witnesses. And once again, that is something to be dealt with at trial or prior to trial. You have something dated, motion to preclude witness statements and police report dated August 5th. Well, police reports typically are not admitted into trial anyway. So that issue becomes kind of moot because it becomes here. Police reports are hearsay unless there's some exception. And I don't know if the state intends to admit the police reports without the officer. Mr. Solaris?
No, Judge.
Okay, so the police report issue is moot. And the motion preclude witnesses. Stassi, explain your motion to exclude witnesses. I'm not quite sure I'm understanding exactly what you're saying.
It's all in the motion, and that was what I filed that August 5th.
August 5th, yes. Well, we're not even sure that Mr. Solaris is going to call these witnesses. So at that time, if there is a motion to preclude witnesses, you can raise, that can be raised at trial. So I'm going to deny at this point in time because it's too early to start raising that because we don't even know if these witnesses, as I note in the record, Scarlett Bunting is one of the witnesses you wish to exclude. And I'm not, if the state's not going to call, it's a non-issue. If they are, then we can deal with it when he discloses what witnesses he wishes to call. So at this point in time, I'm going to deny the motion without prejudice to raise that at a later point in time. So what I'm going to do is I need to do the Rule 8 calculations, and I will get that out, and we'll reset another hearing based on that. If I grant the motion to dismiss, that's the end of the case. If I deny the motion to dismiss, we'll have to set a pretrial conference in order to get the list of witnesses and evidence. So what I'm going to do is set a hearing in 2 weeks. We'll set that as a pretrial conference, but if motion to dismiss is granted, that becomes moot. But at least by the hearing that we're going to have in 2 weeks, just a second, let me look at something. I want the parties prepared to give me a list of witnesses. So 2 weeks is June 5th. Let's go at 3 o'clock.
Okay.
We'll do it once again by Zoom. I assume there's no objections to this.
No objection, Judge.
And Mr. Pototsky, what is your email address that I can send notices to?
It is lr60@yahoo.com.
Okay, that's because I'll do a minute entry and then I'll send out a Zoom invitation. Ms. Troll is no longer with us, so she won't get a copy of the notice, but everyone else will. Is there anything else? If I missed anything, is there anything else out there pending?
No, Judge.
Mr. Pototsky?
Yes, there is considerable.
What? Tell me.
Well, first of all, let's talk about the Rule 8 motion. Now, I don't know how you're excluding anything on that. I filed a 10.2 motion on, I believe it was Judge Wilson.
I show on July 21st.
Yeah, I filed that. Now, immediately, there was a hearing set for that time. Judge Douglas Taylor was assigned to that hearing with absolutely no loss of time on that. So that cannot be any excluded time.
It's almost a month. You filed your 10.2 motion July 21st, assigned to Taylor August 14th. So you got at least a month, approximately a month, 3 weeks.
Well, the hearing was still set for that time. So there was nothing going on between the motion and the hearing. So the 10.2 was, well, first of all, it wasn't granted immediately. They continued to do that. But regardless of that, there was no loss of time on that. Secondly, I filed a 10.1 motion against Taylor, and that resulted in a 4-month delay, which, of course, since it was a motion for cause, removal for cause, and you were assigned to this case, then my motion was granted and it was valid. Therefore, there should be no time lost on that one either. So I don't know what other losses of time that were my fault that could be contributed, or they can be contributed to a delay. Additionally, I have a motion pending regarding additional counsel, which is now just plain counsel. I filed that motion because I went on the case search records online, and I saw Mr. Abrams, who was initially assigned to this. He was withdrawn. Then Ms. Troll was assigned, and then she was removed, and then she was added as a child advisor. And she is, the last I saw on that was she was assigned as a child advisor. I then, not having any counsel, filed a motion for an additional attorney, and I still would like an attorney assigned to me. I did discuss this matter with Judge Wilson, and I requested the Thrush Law Group to be assigned to the case. And of course, he went through, the list and selecting from the list and all that stuff. But I think that the length of time that this case has gone on, over 2 years, and the fact that I've even recently, just within the past week, discovered that Mr. Barth made the same allegation, exactly the same allegation, against another person back in 2010. So what we have here, it's not a complex case, but it is complicated in the fact that we are dealing with a justice of the peace that I participated in having removed from his position. And then he immediately turns around after he heard about him losing his job. He turns around and bumps me in the meeting within seconds of him hearing he lost his job. And then he turns around and twistedly accuses me of assault. So
Well, those are issues we raised at trial. That's not an issue at this point in time.
it,
First of all, it's a trial issue. It's not an issue. I'm not going to make any ruling based on the facts that did or did not occur on the night of that meeting. But first of all, in terms of excluded hearing, anytime you file a motion which causes a change of judge, that's excluded time, no matter whether it's granted or denied. It's excluded time. That's the rules, and that's how I interpret them. That if you file a motion to change a judge, from the date you file it to there's a decision, it's excluded time. And
so you're saying 4 months is excluded?
At least, maybe even more than that. I mean, just
constitutionally and by the rules, that's excluded. That's just.
Yes, it's been way. I have ruled that way over the years consistently, and.
Well, let's put it this way, Judge. I filed an injunction against harassment, and at the Santa Cruz County Court, and within 15 minutes, there was a decision that a Santa Cruz County judge could not hear the case, and then they had a Pima County judge assigned to the case within 15 minutes. 4 months is ridiculous. Now,
you may be true that, but that's what happened. It happened because you filed a motion. You had to look at it this way. If you hadn't filed a motion, there wouldn't have been that delay. So you sort of have to, you bear the burden of that delay.
Well, the fact that I filed the motion and it was granted for cause, then that should not be counted against me. That should be counted against the court.
Merely filing it counts it against you. Whether when it's granted or denied, it goes against you. It becomes excluded time.
Well, I'm still requesting an attorney assigned to the case.
Now, this is something I got to figure. This is something I don't understand. And maybe in Arizona, you're not entitled to appointed counsel unless the state is seeking jail time. Is the state seeking jail time in this case?
No, Judge.
Then you're not entitled to appointed counsel under Arizona law.
Then then why was I appointed 2 attorneys?
That I have no idea why. I mean, that's discretionary. Judge can appoint attorneys in the interest of justice, but I find this case does not rise to that level. This is a simple assault case. It's not complicated. This is something. It
is very complicated. I would disagree with that.
It's simple. It either did or didn't happen. It's as simple as that. There's nothing more to it than that. And by Arizona law, under Arizona law, unless the state is seeking jail, you're not entitled. And in fact, under U.S. constitutional law, you're not entitled to an attorney unless the state is seeking jail. The state has now said they're not seeking jail, so therefore you're not entitled to court-appointed attorney, unless I guess Nogales, the city of Nogales, has a different policy where they appoint them. And that I don't know, and I'll find out. Ms. Romo, is there any written policy about appointing a counsel? This is clerk of court.
we will have to provide the financial statement, Judge, but usually our judges goes by what the rule is, unless the prosecutor is seeking jail on sentences, that's when they appoint an attorney. Otherwise, they will not.
Okay, thank you. So basically what I'm being told, Mr. Pototsky, unless the state's seeking jail, you're not entitled to court-appointed attorney. Now, like I said, judges, even in my court, they can appoint in the interest of justice, but I see no reason why this is an interest of justice in this case.
Are you saying that I have a former Justice of the Peace of Santa Cruz County involved? I have 3 supervisors, county supervisors involved. I have the sheriff in 2 counties involved, and I have probably 100 different people that I have to contact, of which Santa Cruz County has refused to provide me with that information. I am saying that in the interest of justice, I need an attorney and I need an investigator assigned.
Sir, they do that in homicide cases, not in simple assault cases. No, I do not see it as interest of justice. If you want to interview those witnesses, you get busy. But at the same time, I'm not making like I said, this is a simple assault case. Unless those people were present at the time of assault, I find that I'm hard pressed to understand why they even have any relevant testimony. So
they were present. There's probably about 100 people that were present.
Well, then I guess you need to get very busy and start interviewing witnesses and have them ready to be prepared to testify at a trial. It's your responsibility. The state has a responsibility to present its own witnesses. You will present their witnesses. You have the opportunity to present your witnesses. And that's why I said in 2 weeks, we'll have a pretrial conference, determine who's going to disclose your witnesses. And then we'll set a trial date at that point in time. If the motion is denied, if the motion is granted, it's moot. There's no more trial cases over. But like I said, I haven't done the precise calculations, but like I said, just eyeballing it tells me that Rule 8 hasn't been kicked in yet. And keep in mind, pursuant to Supreme Court order, Rule 8 stopped tolling in March. And off the top of my mind, I can't remember if it's March 1st or March 15th. Anything after that date doesn't count pursuant to current Supreme Court order. So it's just the time, and it goes from the time of your arraignment, which was April 30th. It was originally set for the 16th. And so the time counts from, all possible times, April 30th until March, or whether it's 1st or 15th, I forget off the top of my head.
By this number.
So I'll do my calculations. We'll set it here, like I said, in 2 weeks at 3 o'clock, on June 5th at 3 o'clock, and I'll send out the invitation. Is there anything else?
Not from the state, Your Honor.
Mr. Pototsky, anything else?
No.
All right, then I'll see you in a couple of weeks, maybe.
Thank you, Judge.
That's it.
Thank you, Judge.
Thank you.